everybody. This is Gary Berger. I am having our Friday Facebook show. I'm glad everybody's showing up and watching. Last week we had a great show. I really enjoyed it. We had a lot of things to talk about. We gave away our scholarship last week, which was a load of fun. Tiffany from Chicago won it. It was a fantastic interview with her. We discussed a lot of things. After that show, I went straight to join my wife and two of my kids. There was a Black Lives Matter march right around the corner from my house. And we also announced our winner of our Instacart giveaway. We've changed some things up this week, and I noticed last week I really didn't get to, frankly, a lot of questions. So this week I'm going to change that around, and I'm going to try to get to more questions this week. So I'm going to start right away. I have a question from Danielle, who says, my boyfriend slipped at work and tore his meniscus. The insurance company has offered him a settlement. It seems decent. Should he accept? How do we know if it's a good offer? So there's a couple things involved in that question, Danielle. First of all is I think the insurance company, you're talking about a workers' compensation claim. So he's at work, he tore his meniscus. Many times when you tear your meniscus, you need a surgery. So if he's had the surgery and they've paid for all the medical, he has a workers' compensation claim. And if he's got an employer that's working with him and they offer him a good settlement, that can be okay. Remember, in a workers' compensation claim, the employer not only has to pay for all the medical care that's necessary, they have to pay for a lump sum disability settlement at the end of the case, and that's based on your level of disability at a certain level, and that would be at the knee times his weekly wage. So if you're looking at that settlement, you'll need to make sure that they're calculating the average weekly wage correctly. And you'll also want to make sure that they are giving him a good percentage for that, a good percentage for a knee disability. And I've had people with a lot of different recoveries, different types of recoveries from a knee injury. Some people have a meniscus torn and are great. Some people have continued problems or continued issues with that for a long period of time after. So it really kind of depends on how that goes and what their experience is there. So that's something to look out for. So thank you for your question, Danielle. So now the other thing, though, is remember, my firm and most firms will tell you whether or not that's a good settlement. So if you would call us up and then say, hey, here's the basic facts, do you think this is a good settlement? I'd say, well, what percentage of the knee is it? And they'd tell me, and I'd tell you whether that's good or not. And the question is, for me and any other lawyer, is can we add value to that settlement? Could I add value to that? Would it be worth it to pay me my contingency fee? So when I take a case on, typically I get paid a percentage of what I get for people. Is it better to, is it worth paying me? And can I put more money in his pocket or not? And if the answer would be yes, then I would do that. So there's an answer to a question. Let me keep on going and answer another question, just so I keep answering them. I see Davey asks, what is your favorite lawyer movie or TV show? So I think I mentioned this maybe even last week. So, in terms of movies, I guess my two, I'm thinking. I think my two favorite would have to be My Cousin Vinny and The Verdict in terms of movies. My Cousin Vinny, what a great, it's hilarious. And there's a couple of great things about that movie. Number one is it's a great example about how to qualify an expert. So people always talk about how do you get an expert testimony? If you have an expert on the stand, how do you get an expert to testify? And the way he qualifies his girlfriend to be an expert on tire tread and the rear differential when that one tire goes over a bump and slips is great because she's fighting him, she's arguing with him about it. the other great thing is so I was in a motion hearing one time in a big case, and after I got done arguing, my co-counsel, we were driving home or something, and he said, so I think your argument just amounted to stand up and said what he just said is a bunch of bullshit, which is what the lawyer and my cousin Vinny says, which is a great argument. And that's, sometimes that's kind of what you're saying when you're arguing to other lawyers. Well, you want to be a little bit more sophisticated than that. So then of course the movie The Verdict, which is a great movie. In the beginning, Paul Newman is soliciting at a funeral, handing out his card, trying to get the wrongful death case, which is an example. It's contrary to the ethics rules. You can't do that. You're not allowed to do that. Improper. And it's a real story of, as we all know, it's a great movie, a great story about coming full circle and redemption. So then TV show, I don't know if there's any good, the Law and Orders are good, great prosecutorial shows. So there's some lawyer movies and TV shows. Let me move on and answer a couple other questions. How do injury attorneys properly manage their image of being a person who fights for people's rights and justice versus being looked at like ambulance chasers? Well, it's like that movie. So we're talking about movies. There's that movie Slapshot. There's a fine line between clever and stupid. No, I don't think there's a fine line between people who fight for rights and justice versus people like ambulance chasers. Look, at our firm, I've always fight for people. I don't like bullies. I fight against insurance companies and big corporations. I've always fought for individuals. But there's a lot of good lawyers that I know that believe in what they do, and they represent companies too. And everybody deserves a good lawyer. We talked a little bit about that last week, how President John Adams defended the people who fired at the Boston Tea Party, and he was certainly entitled to represent those British officers. So so I think I fight. Now ambulance chasers, so the thing though is that lawyers, like in any other business, have to market themselves and have to do what we can to get business. And so I market myself. I have a Facebook Live show to answer questions and give back to the community, but it's also putting my name out there. I have, YouTube videos. I do different stuff to put myself out there. I'm not chasing ambulances in any way. But there's and people see lawyers sometimes as being it is a profession, but that you shouldn't have to stoop down to the low level of trying to get business. Like a doctor or lawyer shouldn't have to do that, but lawyers do that. So there is a tension there. And one of the ways that we guide ourselves in terms of being a profession is we have ethics rules, and I've been on the ethics commission before, and you can't solicit cases as a lawyer. So we have ethics rules that guide our behavior. One of them is you can't solicit. And I can't, if I know someone who's been in a car crash, I can't call them up and try to get that case. So you can't chase ambulances, and you'll read periodically, and lawyers can, there's always a few bad apples in the bunch. Right now, there are a few bad police officers that are giving police officers a bad name right now in the news. There are many, many great police officers. I know them, and we all know them in our community, and we value them. There's a lot of good lawyers, but there's some lawyers that give lawyers a bad name. And so every once in a while you read about a lawyer who's paying a chiropractor to send him cases, or there was some police officers that in the city that got indicted for giving chiropractors and I think lawyers injury people names. So you can't solicit. That's how attorneys properly manage their image. I mean, you got to do the right thing. David asked another question. Also, do all personal injury attorneys work off the same basic fee structure, or does it differ based on the type, based on the state or the case type. So many personal injury attorneys do work on the same fee structure. Typically, we represent people on a contingency fee basis, which means that I don't get paid until I win your case, David, and I take a percentage of that. The percentage of the case depends on the type of case it is. In a workers' compensation case, I charge 25%. That's the statutory rate. Injury cases are more. There are certain cases that are even more, that are even higher, that are more difficult cases. So I don't want to talk about the fee percentages right now, but any client who ever calls me, I have candid discussions with them about exactly what their percentages are that I would charge, why I do so, and also whether or not what happens with the expenses. And the way I work is that if I win the case, my clients paid me the expenses I advanced on their behalf. But if I lose the case, they eat the expenses. And the reason for a contingency fee is because most of my clients don't want to pay me an hourly rate of $300, $400, $500 an hour, or whatever it would be. They don't have the money or funds to do that, and they want me to share the risk with them. And I happily do that because I want to get them justice and I want to get a good result from them. And then it does so you're not allowed to charge a contingency fee, and there's ethics rules and fees too. There's a whole set of ethics rules on fees. So you can't charge a contingency fee in a criminal case, for example, or a domestic case. So there are ethics rules on fees, and then it depends on the state. There are states that have regulations on fees. For instance, a 25% work comp fee. In Illinois, there's a cap on fees for medical malpractice cases. In Illinois, if you use the Illinois lien reduction statute, there's a cap on fees. So there's a lot of different state regulations on fees, both under ethics rules as well as statutorily, which are two different sources. Let me go through what I would like to do before we get too far afield into this. Into more questions. Now that I've jumped in and answered a few, I'd like to go right away and announce our winner of our food giveaway this week. And I describe it differently on purpose because up until now we've done an Instacart giveaway, and what we've elected to do this week and will continue to change going forward is how we're giving away the money or through what vehicle. This week, what we've decided to do is change this. And I think Instacart was a great way to do it for a period of time because it was hard to get food, and Instacart was a good way to deliver food to people's homes. But we also are big supporters of local restaurants. And so what we've done this week, and we won't be doing Instacart anymore. Instead, we'll be picking a local restaurant. And this week, we've picked Counterculture, which is a great restaurant on Watson Road. Their bricks and mortar location. They have a little place with a lot of great carryout food. So if that now is the time of carryout, Chris and Mark and the different people over at Counterculture are great chefs. It's great food. It's fresh. I know they're at the Tower Grove Farmers Market every Saturday, but Counterculture on Watson Road is a great restaurant. Google them, go there and visit them. And I would also recommend Tina Pruitt. You go there as well because you are this week's winner of the $150 Counterculture gift certificate. So Tina, we're going to give you a $150 gift certificate to Counterculture and go over there. They have a great a ramen noodle with egg mixture that they mix up and cook it. It's awesome. And then they have these sticky buns, these steamed buns, and I get tofu in these sticky buns, which are great. There's a lot of great food there. I know you'll like it. Go there. Go early, go often to Counterculture. It's a great local restaurant. Local people created, great people. Counterculture. They cater parties that I have for friends at my house. I just can't talk enough about how much I like Chris and the people over at Counterculture. So please patronize them. They're a good city restaurant, and we're happy to have them be our partner with our giveaway this week. We have an ad up on our Facebook page and one on our website about talking a little bit about counterculture, and we're happy to give Tina Pruitt, Pruitt, our gift certificate. Tina, message me on Facebook. We'll get it to you, and I hope you enjoy the food. Okay, and we're always, and if anybody here who's watching or anybody who knows, if you have a local business that you like, that you want to support, and would like us to put them in the queue or the line for a future giveaway, message us on Facebook or email me at gary@burgerlaw.com. Get a hold of us. We're happy to support good local businesses and support them with our weekly giveaways that we are continuing. Let me keep going down my list and answer more questions, because this is the Burger Law Ask a Lawyer show. So let's do it. Brennan asked me, hi Jennifer, how are you? So I have a question. Any word on the Missouri DOC case yet? I know I have a lot of corrections officers, friends, and proud to represent them. Jeremy, no word. The case is taken under submission by the Missouri Supreme Court. I argued it to them on April 22nd, so it's been a little bit. They take their time as they should to render these decisions. So we are looking to, we're waiting, and you'll know when I know. I send out email blasts updating my clients in that case, and I will continue to do so. Brennan asked me, Brennan's got the good questions as always. Can I sue if a piece of space junk falls out of orbit and wrecks my garage, or is that act of God territory? Brennan is reaching into space for that question this week. It's a great question. Hopefully it's only your garage that it wrecks. So Brennan, there's no one you can sue necessarily for that. I mean, who owns the space junk? What is it? Is it, around there's, if you read these articles, the amount of space junk, the amount of junk we have orbiting our planet is crazy. With all the stuff we've shot up there, we never take it down and it stays in orbit. Sometimes the orbit deteriorates and declines and comes in and enters our atmosphere. So it does do that sometimes and can fall. We hear about it, but there's no one you can sue. That's act of God. And act of God is interesting. So the idea of act of God means that it won't even be covered by an insurance policy. I think you would have no owner of the space. Let me be clear. You would have no owner of the space junk that you could sue, but you could make a claim against your homeowner's insurance, and they should cover it, and they would repair your garage. That's the only real claim you have. So that's why we have insurance, and they would cover that. That is not storm or something like that. They should pay. They should cover that. So Adam asked me. It's a great question. So as we know, here's his question. I'll just say it to you. If someone requires attendees of their event, say a political rally, to sign a waiver, assuming all risks of COVID, etc., are they actually protected from lawsuits? And Adam is probably referring to, as we've all read in the news, that our president is having a rally in Tulsa to commemorate a terrible tragedy that occurred there. And so I think it's great that we're giving attention to the Tulsa massacre. I don't know if the vein in which it's being done is appropriate in light of some of the other fanning of racial tension that has occurred in our country. However, to answer the question and not be political or too political, is waivers. So if you sign a waiver assuming all risks of COVID, are they actually protected from lawsuits? Yes, most likely. So a well-written waiver is enforceable in many states. It's even more enforceable in states where you can ski, because every state that there is skiing, like Colorado or Utah, they always enforce these waivers. It's kind of funny, or the waiver enforcement is much stronger than it is in other places. So on a waiver, it has to be of a known risk, and it has to be a clearly, reasonably anticipated risk. So I read that waiver. You know what they didn't say in that waiver? They should have said death. They said illness or injury, and they should have said illness, injury, or death from COVID. I think it would have been written better that way. So yes, if you go into an amusement park and you sign a waiver, your kid goes to a birthday party at Sky Zone or a gymnastics place and you sign a waiver, or you go skiing at Hidden Valley or anywhere else and do that. So if you sign a waiver and it's written out and you knowingly waive it, I'm a scuba diver, and the places I scuba dive, I have to sign a waiver every time I go, and the places I work at a scuba diving location, a great gem in Missouri called Bonne Terre Mine. It's unique in the world. And it's unique, and divers come from all over the country and the world to come dive it and have that dive experience. I'm a dive master and a dive assistant instructor there, and we take people diving in that really awesome environment. I enjoy it. It's a passion. So if you sign a waiver for that, you're giving up your right to sue Bonne Terre Mine and these businesses, and it's appropriate. You know, you can't it's hard to operate a business, especially something where some serious injury can happen. You can't afford the insurance if everybody's going to turn around and sue you. So there's a tension there. Now, on the other hand, what about a place that, let's move on to a different example. What about a business that has really dangerous, hidden dangerous conditions that it doesn't tell you about? What if you're signing a waiver and at a go-kart place and the go-kart blows up? Or what if your kid's going to a party and the trampolines break, it bounce you or something? I mean, what if the negligence is really bad and it's not foreseeable? Well, then you got an argument. But I think those would be enforced, because they'll say, listen, even if one of these bad things happen, you're going to waive our right. So be careful of signing waivers. Make sure that if you're going to do it, you get what you're waiving. Make sure that you have adequate insurance yourself for you and your family if you're going to sign a waiver. Because if you're going to sign a waiver and you go to those places, make sure you have health insurance. Make sure you have other stuff to cover you in case someone gets hurt. People don't think about that. Waivers are an affirmative defense, though. Remember that, and we have a case right now. The people have to have the waiver. So as a general policy to sign waivers, that's one thing. But when you sue someone, the defendant has to come up with the signed waiver. And I've had cases too where where we pursued a claim of worthwhile merit, a very meritful claim, where the defendant may have a general policy to have waivers, but they didn't find the one signed by my client. And so if the client didn't sign it, or got through the entryway and they didn't keep it, or if the business didn't keep it on record to protect themselves, then there's no defense, because it's an affirmative defense. They can still sue and file suit against the defendant who had a waiver policy or a policy of having people sign waivers. However, if they don't, but that's it. But then they have to file an answer and show the waiver and move to dismiss the case. So Brennan asks me, you're really into bees. I was curious if bees ever fly solo. Yes, they do. So bees fly solo in a number of circumstances. So did you know that queen bees mate one time in their lives? So a queen, a few days after she is hatched, will go on her mating flight. She will fly out, and about 95% of bees are female. About 5% are male or drone bees. So the queen will fly farther than any other bee, miles and miles, and the male bees will get her scent, will come and will impregnate her. And so she does one flight, and then she comes back and she has all, and I don't want to get into the sex act, but she has all the stored material in her body at that time to lay thousands and thousands of larvae for 2 or 3 years. Then bees do other solo flights. So a lot of bees fly solo. So like right now, it's the honey. It's a good time to make honey for bees. It's the highlight of the time of honey production. There's a honey flow going on right now, which means a lot of nectar where bees can go out and get the nectar and make the honey. In fact, I need to go put some more boxes on my hives to collect more honey. I had planned to do it this week, but it got away from me. I got to work on that tomorrow. So yes, all those bees, those forager bees, the ones that go out and get pollen and nectar, do fly solo. And they all fly and they know exactly where to come back to their hive. I think I mentioned that the other day on another Facebook live show. They can go up to 2 miles and know exactly where they are. I have hives that are right next to each other, and a bee will go away, will fly 2 miles, and I'll show you guys a picture of them right now while I'm talking here. A bee can go and fly 2 miles and come back, and it will come back to that exact hive. It won't go to the hive 2 feet away from it. It will go to that exact hive. Let me show you this picture. So here's a picture of my hives, if you can see it. Oh, so look at that. Those hives are all right next to each other. And a bee is going to fly 2 miles and come back, and there's 5 hives there. And it's going to go back to that hive and not go to one next to it. So the forager bees do that. They all fly solo. And they get their visual cues from trees and different things just so they know where to go. They'll go out 10 feet and come back, 20 feet and come back, and they calculate exactly how to get home. If you move the hive, they'll never find their way home. The way you transport hives to deal with that is that at night when they're all in there sleeping, you plug at the holes by either a netting or screen. I have little holes in mine. I put wine corks in some of the holes, and then or you tape them over and then you move them, because any bees that are out when you move the hive, they'll never find their way home and they'll die alone. So let me move to another. Thank you, Stephanie loves my jacket and tie. Thank you. This is one of my seersucker suits. I bought this from a guy named, there's a great suit shop in Jefferson City, Missouri, catty corner from the courthouse there. Sam has a great suit shop, and I bought this dark, or this black, they call it, gray seersucker suit there. I have another question for you. I have another question to be answered. What are the most, sorry, lost my train here. I think I'm caught up on this. What are the most difficult cases for you? Class actions, medical malpractice, and what makes them so difficult? Well, the most, so the question, so it's a great question. What are the most difficult cases? Well, cases can be difficult in different ways. Class action cases are difficult because you're dealing with a huge number of people, usually a recalcitrant defendant who's going to fight tooth and nail. You're talking about a lot of money typically, because these claims aggregate to a lot of money. So even if one person has $1,000 in damage, if you have 1,000 people in the class, it's $1 million. So the claims aggregate to big numbers, and then the reality is people sometimes it's a little esoteric when people hear the arguments that politicians make about appointing judges, but so right now there's Mitch McConnell held up a lot of, when Obama was president, Mitch McConnell held up a lot of his appointments, did not appoint Merrick Garland, kept it in his pocket for the last year of Obama's presidency, and then and put Kavanaugh on the bench, and then Trump put Kavanaugh on the Supreme Court, and there's a lot of other judges as trial court levels. So there's a lot of reasons why that's important. One of them is the political nature of the Supreme Court and how it's making political decisions on hot button social issues. But the other reason why judges are so important is because they're making the trial court judges are making trial court decisions on a daily basis and deciding the fates of people. So a judge can, at their discretion, certify or not certify a class action case. And if you could have the exact same set of facts in a case, and a more conservative judge or Republican judge or pro-business judge may not appoint a class, may not prove that as a class action, versus a more moderate judge would. So one of the reasons why class action cases can be difficult is that you're subject to sometimes can be subject to you're always subjected to the discretion of the judge, and I have no problem doing that every day of the week. However, if the discretion of the judge is meted out through a political lens rather than just the straight analysis, objective analysis of the facts, that can hurt you. So I've had cases where I've had class action cases where I was shocked that it did not get certified. And then the case is wrecked. You can't, then you settle it on all the individuals, and let's say you represent 10 or 20 people who've actually hired you, but you want to represent the thousands of people who don't know that this company committed fraud, or this company broke the law, or this company is acting unlawfully, or this company, scammed people, who knows what it is, then you don't get justice for those people. So that's really tough. Medical malpractice cases can be difficult because they can be difficult to win in court because people like their doctors and people want to like their doctors. We're built as humans and in our society to like our doctors and not to want to think they're fallible. Because if you're on a jury and you are going to find that doctor who's being sued in that case, if you're going to find that he was negligent, what does that say about your own doctor who just told you that your tests are clear and you don't have cancer, or said that you're healthy? You don't want to admit the errors of the physicians or sometimes because you don't want to admit that. And we put white coats on doctors. We put them on a pedestal. We want to. And doctors are great people. They work so hard. They're such dedicated people. The other reason why medical malpractice cases are difficult is the insurance lobby has spent a lot of time lobbying to convince Americans that, or try to sway Americans' opinions that there's all these frivolous medical malpractice actions out there. I remember during the Bush administration, like 20 years ago, he'd say frivolous malpractice cases, and I'm like, malpractice cases are so hard fought, they're so vigorously defended. There are no frivolous medical malpractice cases. You can't even win good. It's really hard sometimes to win good malpractice cases. So malpractice cases can be difficult because of the societal perceptions of them, and sometimes you're rowing upriver on them. But I like them. Because look, the doctors have clear rules to abide by, and the doctors know the rules, and if they take you as a patient, just like me as a lawyer, I got rules that I got to abide by. And so a doctor, a lawyer, anybody else, when you break the rules, you're responsible for any unnecessary harm that those rule breaking cause. And you should be held liable to that. And doctors who are negligent or make mistakes that unnecessarily kill or injure people should be responsible for that. And that's what I tell juries. And if you put it that simply and try to make a clear case of it, I think that doctors should be held liable. And they are. Many times juries do find doctors liable for their negligence, and not more than their negligence, and don't award more than the full recovery for the damages. But it is what it is, and we all know that. So, great. I think that's it. And there's a lot of other difficult cases too. I mean, you know, uh, uh, sometimes, trucking cases can be difficult because of the level of damages involved, and the vigorous defense that's put up. So every case has its own challenges. Every case is different, unique factually. And one of the things that I love about, I'm so blessed to have the job that I have, and be able to do what I do. But one of the interesting, what I always say too is, so in any one of these cases, so to succeed, a plaintiff has to jump through hoops, and if they ever don't make it through one of the hoops, they lose the case. So you have to make it through all the hoops. You could make it through 10, but if you don't make it through number 11, your case is gone. So you have to successfully jump through the hoops. And the other thing good lawyers do on the plaintiff and the defense side is we find other ways to solve problems. So where there's always obstacles are thrown up in a case. This fact doesn't go your way. You can't get this medical in, blah, blah, blah. And so what good lawyers do is you always have to find workarounds to all the changes that a case throws at you. That is true for anybody in life. That's true for anybody who runs a business, anybody who does anything. You've got to find your workarounds and people who run businesses, CEOs, managers. You got your own business. And different professions. Anyway, that's one of the things you have to surrender to as a lawyer is, the perfect case doesn't come along that often. And you always are going to have to find different ways to prove a point, to show a jury damages, to prove a defendant is liable, to catch a defendant or his employee in a false statement, to show why a product was dangerous, or to show the defendant knew a product was dangerous, or to show the fraud, for instance, that a company might do on a class-wide basis. And so proving that and showing that, there's great, people love those stories of the underdog who goes out and finds the company that's dumping the chemicals into everybody's drinking water, or that did that other thing. People love those stories when you catch those people, and you lawyers just have to do that. Okay, let me move to another question. Adam asks, I don't know too much about things like the CHAZ, the Chaz in Seattle right now, but do normal laws, regulations, or consumer protections still apply in places like that? So, yes. I don't know if I'm getting the question, Adam. But it is a good question. But yes. So, normal laws, regulations, consumer protections do apply everywhere in America, in Seattle or anywhere else. And you'll have different levels of those, though. So you'll have federal consumer protection laws. You'll have statewide consumer protection laws. There's also a question of how those are enforced. Many times consumer protection laws are enforced by lawyers like me who sue or make a claim for that. But most attorney generals in most states have state consumer protection enforcement agencies as well. So consumer protection laws are a little bit of a weird thing. They're like, the FDA. Thank you. Someone put up, one of our people, Chaz, Capitol Hill. It's an autonomous zone, police-free autonomous zone. Yeah, all the laws still apply. The question is enforcement. So you can't steal, but if you steal, there's not going to be a policeman who's going to catch you. You can't. So enforcement. So you still have consumer, you still have normal laws, but you can't go kill someone in that. Thank you, Adam. I see the comment line. So you can't go kill someone in that zone. You still killed someone. You're still guilty for murder. Although with the lack of police, you're not going to get caught. Similarly, if you're African American in that area, you're much less likely to be killed by a police officer or to be racially profiled by a police officer. So, and that's a commune-style self-enforcement, community enforcement. that kind of stuff. There isn't a lot of times as communities, we already do that. I help my neighbors out, and we do have police. This isn't a police-free zone, but, us neighbors watch out for each other. All communities do that. And they should. We should maintain this sense of community. So the laws are the same. Enforcement may be different. I think that's the essence of my answer. Is that's it. The laws are the same. It's still the same deal, but you're going to have a lack of enforcement there, and it is what it is. Remember too, though, that and I've talked about this in other shows. Interesting. So we have different levels of laws in our community. You will have our federal law. You'll have your state law. You have our local and municipal law, and those all have different both statutes as well as regulations. So, when you do something, you might not be violating a local or state law, but you be violating a federal law, or vice versa. So I loved today's show in that we ranged over a lot of different variety of questions and a variety of different topics people were asking about and that we talked about. Again, congratulations to Tina Pruitt, who won our counterculture giveaway, and we're very happy and proud to represent counterculture. Go to counterculturestl.com. That's with K's. Counterculture with a K. It's in the feed on this. Go to that. And then one last question that I did have is a question about, can you file a suit or file a claim with all these police attacks and police what's the law on that? And the law is these cases are tough. So police forces can pay out a lot of money. There's an article this week that St. Charles paid $325,000 in an inmate who was attacked by another inmate this week, and to settle a case. Police departments and jails pay out claims all the time, like $1 billion a year in claims, some huge amount of money because officers, both corrections officers or police officers, may break the rules that they're supposed to abide by. And those cases, however, I think those cases are difficult. There's also a lot of examples of those cases going to trial and losing because jurors like to protect officers and like to ensure and want to protect officers, because a lot of times officers are exercising their discretion as well as they can. Obviously, sometimes they're not. We've seen with Mr. Floyd, we've seen examples of that not happening. But there's also officers also are granted a level of immunity for their actions, and they call it qualified immunity. So to make an officer liable for a conduct, they have to show that their action clearly violated constitutional guidelines and show that there was a prior case saying that. And so although our office does do those cases, they are difficult to prove. And I had that question come up this week, and I wanted to make a quick note about that. Well, that's all the questions I see in my feed. I appreciate everybody's attention this week for our weekly Ask a Lawyer show. Tune in next week for another show. We're going to find another local business to support with another gift certificate giveaway. Thanks everybody for watching. Everybody have a great week, and everybody be safe out there. Remember, just because the restrictions and the corona and coronavirus restrictions have come up, that doesn't mean we're stopping to wear face masks, stopping social distancing or anything. It's important time as ever. In 12 of our 50 states, the numbers of COVID is higher than it's ever been. So everybody be safe out there. Oh, And that is, remember the old TV show Hill Street Blues? That had lawyers in it. That's what they would say whenever the cops went out in Hill Street Blues. Be safe out there. So I leave that last word to everybody watching. Thank you.